This is arguably worse than Nixon's Saturday Night Massacre. Open corruption is on full display at the Department of Justice. Because acting Deputy Attorney General Emile Beauvais III appears to have brokered a backroom deal with New York City Mayor Eric Adams. Help push Trump's immigration agenda, and the feds will kill the corruption case against you. A classic quid pro quo. But when Beauvais ordered U.S. Attorney Danielle Sassoon to file a motion to dismiss, she refused and instead resigned. Her letter to Attorney General Pam Bondi set off a mass exodus that will probably be remembered as the Thursday Night Massacre. And when Sassoon quit, Beauvais demanded some other attorney do his dirty work. No one stepped up. And one by one, they chose the door instead. As one said in his resignation letter, quote, "I expect you'll find someone foolish or cowardly enough to file your motion, but it was never going to be me." As of the time of this recording, at least 7 prosecutors have resigned in protest. Desperate, Beauvais and Bondi forced the remaining members of the Public Integrity Unit, or PIN, into a room, Squid Game style, and gave them 1 hour to pick who would eventually carry out the order, or they would all be fired en masse. This is so much worse than Nixon's Saturday Night Massacre. Now, why do I say that? Well, because we've been here before. On October 20th, 1973, President Richard Nixon tried to fire Special Prosecutor Archibald Cox, who was investigating the Watergate affair. Cox had subpoenaed Nixon's secret Oval Office recordings, which contained crucial evidence of White House misconduct. Nixon refused to comply and instead offered a compromise. A summary of the tapes prepared by Democratic Senator John Stennis, a Nixon ally who was basically deaf. Cox rejected that offer, insisting on the full tapes instead. In response, Nixon ordered Attorney General Elliot Richardson to fire Cox. Richardson refused and resigned in protest. Nixon then ordered Deputy Attorney General William Ruckelshaus to fire Cox, but he too refused and resigned. And finally, Solicitor General Robert Bork, who had then become the acting Attorney General, complied with Nixon's demand and fired Cox. Now, that was only a few months before Nixon resigned. And at the time, this was a historic presidency-ending scandal. But what a difference 50 years makes. Now, as we talked about last year, a federal grand jury indicted New York City Mayor Eric Adams for accepting bribes, wire fraud, soliciting campaign contributions from foreign nationals, and conspiracy. The indictment alleges that Adams and his staff received hundreds of thousands of dollars in free flights and hotels from the Turkish government, and alleges that Adams used straw donors to bypass federal campaign finance laws and misused the New York City Public Matching Fund system to receive over $10 million in public funds for his 2021 mayoral campaign. The government alleges that in return, Adams gave political favors, such as overruling the New York City Fire Department's determination that the new Turkish consular building was unsafe. The FDNY found 60 violations that needed to be handled before the skyscraper could open to the public. And according to the indictment, Adams intervened, and the FDNY officer who made the recommendations was told he would be fired if he didn't acquiesce, and the, quote, skyscraper opened as requested by the Turkish official. And in December, prosecutors notified the court that they discovered more illegal conduct by Adams, including destruction of evidence, and that they would probably file a superseding indictment to that effect. Now, reporting indicates that acting Attorney General Beauvais didn't care about any of this. He set out to make a deal with Adams that would please Trump and sought to use the criminal allegations to their advantage. Note that Beauvais worked diligently on the January 6 prosecutions before leaving the DOJ and defending Trump. Now, Mayor Adams did not resign when he was indicted, and it seems that he determined that his best chance of political and personal survival was to cozy up to Trump. And to that effect, Adams' lawyers are William Burke and Alex Spiro. Spiro also represents Elon Musk, and Burke recently became an ethics advisor to Trump's private companies. Now, shortly after Trump took office, lawyers for Adams apparently asked Trump to pardon the mayor. But instead of a pardon, they got a call from Emile Beauvais. And until recently, Beauvais was one of Trump's many criminal defense lawyers. Trump nominated Beauvais as the Principal Assistant Deputy Attorney General, or PADG, which does not require Senate confirmation. He is currently acting Deputy Attorney General, while Trump's other personal attorney, Todd Blanche, goes through the confirmation process. For 2 years, it's reported Beauvais was one of 2 chiefs of the Terrorism and International Narcotics Unit in the Manhattan U.S. Attorney's Office. His tenure was reputedly a disaster. A judge slammed Beauvais for, quote, grave derelictions of prosecutorial responsibility and identified, quote, systemic prosecutorial misconduct in a case involving alleged evasion of sanctions. The judge said the prosecution was, quote, marred by repeated failures to disclose exculpatory evidence. As we've talked about before, the failure to disclose exculpatory evidence, generally known as a Brady violation, is a serious ethical breach and can result in convictions being overturned. And that's what happened when Beauvais and the team of prosecutors he supervised prosecuted a defendant who had been convicted on several counts of evading sanctions against Iran. Prosecutors asked the court to vacate the jury verdict. Then District Court Judge Allison Nathan blamed the co-chief, saying, quote, the supervising unit chiefs appear to have offered little in the way of supervision. And Beauvais left the Justice Department shortly after the case went sideways. But in stunning allegations here, the New York Times reported that Beauvais essentially coached the mayor's defense team on what talking points to use ahead of time and got them on board with the unorthodox immigration policies for no prosecution plan. That led to a meeting between Beauvais, the defense team, and acting U.S. Attorney for the Southern District of New York, Danielle Sassoon, the prosecutor who had inherited the case. Now, during that meeting, Beauvais allegedly steered the conversation to how the changes hurt the mayor's ability to fight illegal immigration in New York City. Beauvais also wanted to know whether it hurt the mayor's re-election prospects, which yes, it should hurt one's re-election prospects if you are alleged to have engaged in abject criminality. But as we'll discuss in a second, U.S. Attorney Sassoon summarized what went down here. Quote, I attended a meeting on January 31st, 2025 with Mr. Beauvais, Adams's counsel, and members of my office. Adams's attorneys repeatedly urged what amounted to a quid pro quo, indicating that Adams would be in a position to assist with the department's enforcement priorities only if the indictment were dismissed. Mr. Beauvais admonished a member of my team who took notes during that meeting and directed the collection of those notes at the meeting's conclusion. Now, admittedly, it's not usually the lawyers who engage in the Stringer Bell defense.
Is you taking notes on a criminal fucking conspiracy?
Now, Beauvais has subsequently admitted that he told someone to confiscate the notes, but said it was in the name of preventing leaks, which is weird because the existence of notes have no bearing on whether someone leaks the content of a meeting or not. Notes are merely a record of what happened.
Is you taking notes on a criminal fucking conspiracy?
I guess the answer was yes. And a few days after that meeting, Beauvais ordered acting U.S. Attorney Sassoon to drop all charges against New York City Mayor Eric Adams and issued a public memorandum to that effect. Now, amazingly, Beauvais' memorandum explaining his rationale says it has absolutely nothing to do with the, quote, strength of the evidence or the legal theories on which the case is based, which are issues on which we defer to the U.S. Attorney's Office at this time. That alone was basically unprecedented and stunning. But at the time, Beauvais had no criticism of Sassoon or her staff. In fact, he told her, quote, this directive in no way calls into question the integrity and efforts of the line prosecutors responsible for the case, or your efforts in leading those prosecutors in connection with a matter you inherited. So why on earth would Beauvais want to dismiss this case? Well, facially, he questioned the actions of former U.S. Attorney Damian Williams, which Beauvais said, quote, threaten the integrity of the proceedings, including by increasing the prejudicial pretrial publicity that risks impacting potential witnesses and jury pool. Now, we'll talk about those allegations in a second. And according to Beauvais, quote, it cannot be ignored that Mayor Adams criticized the prior administration's immigration policies before the charges were filed. Now, Beauvais' memorandum explicitly says it doesn't question that the prosecutors had enough evidence to bring these charges before a grand jury or that there was enough evidence to win the case. And the memo also doesn't mention the other 3 criminal cases filed against Adams' aides, which rely on much of the same evidence cited in the Adams indictment. Additionally, Beauvais' second reason for seeking dismissal is that the, quote, pending prosecution has unduly restricted Mayor Adams' ability to devote full attention and resources to the illegal immigration and violent crime that escalated under the policies of the prior administration. We are particularly concerned about the impact of the prosecution on Mayor Adams' ability to support critical ongoing federal efforts as described in Executive Order 14165.1. Now, in a way, it's helpful that they are so incompetent and that they say the quiet part out loud. This rationale doesn't make any sense. Adams isn't the only person capable of handling important security issues in New York City, but also, yeah, being engaged in and being indicted for unrelated corruption will hamper your efforts to be the mayor. So Beauvais ordered Sassoon to file a motion for leave to dismiss, but nothing appeared on the docket. Now, at the time of this memo, anyone who read it knew that something corrupt was going on because the motion sought to ask the judge to dismiss the case without prejudice. A dismissal without prejudice means the case is dismissed, but the government has the right to refile charges in the future. Well, on the other hand, a dismissal with prejudice permanently ends the case, preventing the government from prosecuting the defendant on those charges ever again. Now, if you thought the process was tainted, you would either cure the infirmity, which, as we'll talk about, is what Sassoon wanted to do, or you dismiss with prejudice so the prosecution is done. But in this case, dismissal with prejudice allows the administration to hold future prosecution over the head of Mayor Adams. Tom Homan, Trump's border czar, even admitted this in a joint appearance with Adams on Fox News.
If he doesn't come through, I'll be back in New York City, and we won't be sitting on the couch. I'll be in his office, up his butt, saying, where the hell is the agreement we came to?
Yes, so funny. So if the charges are dismissed without prejudice, the Trump administration can hold future prosecution over the head of Eric Adams like the sword of Damocles and get him to do what they want. So in response, a few days later, acting U.S. Attorney for the Southern District of New York, Danielle Sassoon, submitted her conditional resignation to Attorney General Pam Bondi, quitting in protest of the order to dismiss the Adams case. Now, Sassoon is a prosecutor who's probably best known for her cross-examination of Sam Bankman-Fried during his fraud case. Now, Sassoon has deep conservative roots, having clerked for Supreme Court Justice Antonin Scalia and Brett Kavanaugh when he was a member of the D.C. Circuit. She's also a member of the Federalist Society. But 3 weeks ago, she was handpicked by the Trump administration to take over as acting U.S. Attorney for the Southern District of New York, while Jay Clayton, Trump's pick to run SDNY, went through the confirmation process. And she's 8 months pregnant right now, so you can bet she doesn't need this crap right now. Now, Clayton previously created his own mini Saturday Night Massacre. You might recall in 2020, Bill Barr tried to fire then U.S. Attorney Jeffrey Berman, who was the U.S. Attorney for the Southern District of New York, and replace him with Clayton, who was the head of the SEC at the time. Berman refused because Clayton had no experience as a U.S. attorney or as a prosecutor. So it's fun, we get to relive that. Okay, one scandal at a time. Now, U.S. attorneys take 2 oaths upon assuming office. The first is the constitutional oath taken by all federal employees, quote, I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I'm about to enter, so help me God. Second, here Sassoon took a jurisdictional oath as a member of the New York State Bar, quote, I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New York, and that I will faithfully discharge the duties of the office of attorney and counselor at law according to the best of my ability. But Sassoon informed Attorney General Pam Bondi that, quote, I cannot credibly represent the government before the courts if I seek to dismiss the Adams case on this record. So let's hear from Sassoon in her own words about what happened and why. Quote, on February 10th, 2025, I received a memorandum from Acting Deputy Attorney General Emile Beauvais directing me to dismiss the indictment against Mayor Eric Adams without prejudice subject to certain conditions, which would require leave of court. When I took my oath of office 3 weeks ago, I vowed to well and faithfully discharge the duties of the office on which I was about to enter. Sassoon said her oath as a U.S. attorney includes making, quote, only good faith arguments and not using the, quote, criminal enforcement authority of the United States to achieve political objectives or other improper aims. And that was exactly what Beauvais was doing. He admitted as such. Beauvais cited 2 reasons for dismissing the Adams case, none of which had anything to do with criminal justice. First, because the mayor promised to enforce Trump's immigration priorities in New York City, and second, because Beauvais claimed that former U.S. Attorney Damian Williams weaponized the Department of Justice. Now, Beauvais did not deny that there was substantial evidence that Eric Adams committed crimes, and yet, quote, Mr. Beauvais appears prepared to concede that Adams should receive leniency for federal crimes solely because he occupies an important public position and can use that position to assist in the administration's policy priorities. Federal prosecutors may not consider potential defendants' political associations, activities, or beliefs. See Waite versus United States, politically motivated prosecutions violate the Constitution. If a criminal prosecution cannot be used to punish political activity, it likewise cannot be used to induce or coerce such activity. Threatening criminal prosecution, even to gain an advantage in civil litigation, is considered misconduct for an attorney. See, for example, DC Bar Ethics Opinion 339, ABA Criminal Justice Standard 3-1.6, quote, a prosecutor should not use other improper considerations, such as partisan or political personal considerations, in exercising prosecutorial discretion. Sassoon then quoted Pam Bondi to Pam Bondi, quote, in your words, the Department of Justice will not tolerate abuses of the criminal justice process, coercive behavior, or other forms of misconduct. Dismissal of the indictment for no other reason than to influence Adams's mayoral decision-making would be all 3. This is a classic quid pro quo. Quote, Adams's advocacy should be called out for what it is, an improper offer of immigration enforcement assistance in exchange for a dismissal of his case. Although Mr. Beauvais disclaimed any intention to exchange leniency in this case for Adams's assistance in enforcing federal law, that is the nature of the bargain laid bare in Mr. Beauvais' memo. That is especially so given Mr. Beauvais' comparison to the Bout prisoner exchange, which was quite expressly a quid pro quo, but one carried out by the White House and not the prosecutors in charge of Bout's case. Now, I probably don't need to tell you, it is extraordinary for a U.S. attorney to accuse the 3rd highest ranking lawyer in the Justice Department of entering into a quid pro quo deal of this nature. But Beauvais himself compared the quid pro quo between Trump and Adams to the deal between Russia and the United States to release notorious Russian arms dealer Victor Bout in return for American gold medalist Brittany Griner. Sassoon called that analogy particularly alarming. That prisoner swap was an exchange of official acts between separate sovereigns, the United States and Russia, neither of which had any claim that the other should obey its laws. By contrast, Adams is an American citizen and a local elected official who is seeking a personal benefit, immunity from federal laws to which he is undoubtedly subject. In exchange for act enforcement of federal law, he has no right to refuse. Now, I would compare this to another Russian deal, the one where President Trump tried to solicit a bribe from Ukrainian President Volodymyr Zelensky by refusing to send congressionally appropriated military aid to Ukraine unless he did him a favor of finding or fabricating dirt on his political rival, Joe Biden. Now, since it's been in the news so much, I will remind you that too was an act of impoundment that the president had no authority over. But admittedly, in some sense, this is a little different because with the Ukraine blackmail, it was purely for Trump's personal interest, where here it goes to effectuate political goals. But that's not how criminal prosecutions work. You are not supposed to withhold prosecution against a murderer, for example, just because they agree with you about, I don't know, vaccine mandates or something. And there is also one tiny reason why you don't offer a politician a personal benefit like dismissing criminal charges on the condition that they perform or not perform an official duty. There's a technical term for it. It's on the tip of my tongue. Oh, bribery. If Mayor Adams had discretion in the performance of the immigration-related actions, there is a colorable argument that Beauvais attempted or successfully bribed him to perform his official acts. Now, the counter-argument is that the Trump administration was simply giving him a personal benefit to induce him to perform actions that he was otherwise required to perform, though that goes back to problem number 1. But on these facts, I don't know. I hope Beauvais doesn't want to see any Broadway shows anytime soon. I'm just kidding. Hamilton is obviously going to be shut down as DEI. But Beauvais' second rationale for dismissal is that former U.S. Attorney Damian Williams, who's a Democrat, weaponized the Department of Justice against Mayor Adams, obviously another Democrat. This was a talking point of Adams that Beauvais adopted, and Mayor Adams played this up for Tucker Carlson in late January of 2025, just as negotiations between his lawyers and Beauvais were heating up. Adams' lawyer Spiro had filed papers with the court a few weeks back that the prosecution should be dropped because U.S. Attorney Williams, who had already left the Department of Justice at this point, wrote an op-ed about how New York was in crisis. Now, the judge, Judge Ho, rejected Adams' argument, finding that the op-ed referred mainly to the problems with New York State and that the op-ed only made an oblique reference to ethical problems, which did not name Adams specifically, did not contain any opinions on Adams' guilt, and did not go beyond the public record. So Sassoon pushed back on the allegations about Williams' motivations and actions. Quote, "If anything, I have learned that Mr. Williams' role in the investigation and oversight of this case was even more minimal than I had assumed. The investigation began before Mr. Williams took office. He did not manage the day-to-day investigation, and the charges in this case were recommended or approved by 4 experienced career prosecutors, the chiefs of the SDNY Public Corruption Unit, and career prosecutors at the Public Integrity Section of the Justice Department. Mr. Williams' decision to ratify the recommendations does not taint the charging decision. And notably, Adams has not brought a vindictive or selective prosecution motion, nor would one be successful." And Sassoon criticized Beauvais' assertion that the prosecution was timed to hurt the mayor's chances at re-election. Adams was indicted 9 months before the Democratic primary, and similar timing occurred in corruption charges against Senator Bob Menendez, convicted, and Representative Duncan Hunter, convicted and then pardoned by Trump. Now, Sassoon said that Adams chose the timing of his trial and that he could have delayed it until after the primary. He chose before, even though he knew, quote, the burden trial preparation would place on his ability to govern the city or campaign for re-election. But that is his choice, and the district court has made clear that Adams is free to seek a continuance. The parties therefore cannot argue with candor that dismissing serious charges before an election, but holding open the possibility that those charges could be reinstated if Adams were re-elected, would now be other than clearly contrary to the manifest public interest. I'm not aware of any instance in which the department has concluded that an indictment brought this far in advance of an election is improper because it may be pending during an electoral cycle, let alone that a validly returned and factually supported indictment should be dismissed on that basis. And Sassoon explained that her office was preparing new charges against Adams, which would have been done long after former U.S. Attorney Williams had left. Quote, "We have proposed a superseding indictment that would add an obstruction conspiracy count based on evidence that Adams destroyed and instructed others to destroy evidence and provide false information to the FBI, and that would add further factual allegations regarding his participation in a fraudulent straw donor scheme." And in our video on Adams, we talked about the probable destruction of evidence by several of the mayor's associates. Mohammed Bahi, one of the mayor's aides, is already facing charges of witness tampering and destroying evidence. Now, not surprisingly, Adams consented to a dismissal without prejudice, which means the department could refile a criminal case later. Sassoon claimed that Beauvais negotiated this deal without informing her office, and the offer is dangerous and corrupt. She suggested that the judge may not even grant the motion to dismiss. Quote, "Adams's consent would not guarantee a successful motion given the basic flaws of the stated rationales for dismissal." Basically, she is waving a red flag saying that Judge Ho should make an inquiry into this dismissal. And Sassoon said that Beauvais' order requires her to violate her ethical obligations. Quote, "Because I do not see any good faith basis for the proposed position, I cannot make such arguments consistent with my duty of candor." And she's probably right. Ethical duties prohibit a lawyer from taking positions that are contrary to law or outside the bounds of reasonable advocacy. Sassoon closed the letter by asking Bondi for a meeting. Quote, "In the event you are unwilling to meet or reconsider the directive in light of the problems raised by Mr. Beauvais' memo, I am prepared to offer my resignation. It has been and continues to be my honor to serve as a prosecutor in the Southern District of New York." Now, I wanted to take a step back and get a gut check on this outrageous behavior. So I asked former AUSA Mitchell Epner for his thoughts on the magnitude of Sassoon's letter about Beauvais.
Thanks, Devin. I'm very appreciative of the opportunity to speak about this. I am speaking on my own behalf, and I am speaking as a former federal prosecutor. When I became a federal prosecutor, the mantra that was drilled into me was that we needed to act without fear or favor, meaning that we needed to act without fear of the personal consequences, and we needed to act without favor or disfavor to any potential defendant on the basis of who they were or how powerful they were. That is the mantra of the Department of Justice. That is something that Danielle Sassoon picked up in her truly amazing letter to Pam Bondi, the Attorney General, explaining why she could not go along with moving to dismiss the charges against Mayor Adams. That letter is one of the bravest, most courageous things that I have ever seen any lawyer do, and I tip my hat to her. Danielle Sassoon is somebody who I did not expect to become my hero. She and I have very different political views. She is a Federalist. She was a clerk to the late Justice Antonin Scalia. She is a dyed-in-the-wool conservative. She did not do what she did because of politics. She did this because of her adherence to the motto, the creed, and the mission of the Department of Justice. So moving one step forward, this is important because everybody in the Department of Justice needs to know that the prosecutions will move forward without fear or favor. When I was an AUSA, I asked FBI agents, DE agents, others to go in the line of duty into danger, face possible death. And they needed to know that the cases that they put together would be prosecuted or not prosecuted based upon their strength, not based upon what the defendant knew, who the defendant could ask favors from. That is what we stood for. That is what the Department of Justice has always meant to stand for. That is what Danielle Sassoon stood up for. And that is under attack from Pam Bondi, Emile Beauvais, and what they are doing with regard to dismissing the charges against Mayor Adams. Now, we know that the decision not to pursue the charges against Mayor Adams has nothing to do with the underlying facts, because Emile Beauvais put that in the initial 8-page memo he sent demanding that the charges be dropped. And it is highly problematic that the demand was that the charges be dismissed with the possibility of them being reinstated in November after the results of the election were known for mayor.
So yeah, that checks out, unfortunately. We'll come back to Mitch about what's going to happen next in this case, but we still have a lot to get through. Beauvais gleefully accepted Sassoon's resignation, even though he didn't technically have authority to do so. Only Attorney General Pam Bondi did. Beauvais' praise for the prosecutors and their integrity evaporated when he read Sassoon's resignation letter. He fired back, accusing her of continuing to pursue a politically motivated prosecution. He accused her of betraying her oath despite express instructions to dismiss the case, and said she lost sight of her oath by disagreeing with, quote, the policies of a democratically elected president and a Senate-confirmed attorney general. Now, reminder for all the attorneys out there, no matter how much you like a president's policies or not, they do not override your ethical obligations as a lawyer. The ends don't justify the means, something, something, something. Now, Beauvais defended his actions by referring to Trump's executive order. Quote, the weaponization finding in my February 10th, 2025 memorandum was made pursuant to a policy set forth by President Trump, who is the only elected official in the executive branch, in connection with a decision that was authorized by the Senate-confirmed Attorney General of the United States and entirely consistent with guidance issued by the Attorney General shortly after that confirmation. Your office has no authority to contest the weaponization finding or the second independent basis requiring dismissal set forth in my memorandum. The Justice Department will not tolerate the insubordination and apparent misconduct reflected in the approach that you and your office may have taken in this matter. Beauvais again accused former U.S. Attorney Damian Williams of making incendiary statements about Mayor Adams, which apparently demonstrated bias and prejudiced the jury pool, that Williams, quote, launched a personal website which closely resembles a campaign website that touts articles about the ongoing prosecution of Mayor Adams with titles such as U.S. Attorney Damian Williams has come for the kings, a mayor, a rapper, a senator, a billionaire, meet the man who has prosecuted them all, and former prosecutor Damian Williams flexes SDNY power against Eric Adams and Sean Combs. And also said that reviewing the voluminous evidence against Adams would burden the mayor's ability to run a campaign and do his job. Quote, in October 2024, an AUSA responsible for the prosecution of Mayor Adams represented that the first batch of discovery in the case included about 560 gigabytes of data. Thus, as a trial date was negotiated, Mayor Adams was faced with an impossible choice between seeking to defend himself at a pre-election trial and in the hopes that he could campaign based on exoneration, and taking a reasonable amount of time to review the discovery and prepare his defense at a post-election trial. His acquiescence in the former option does not justify your office's decision. And this is exactly the sort of thing that Beauvais wrote when he was Trump's defense lawyer. That there's so much evidence of criminality he won't have time to be mayor is not quite the pone that Beauvais thinks it is. Finally, your suggestion that President Trump should issue a pardon to Mayor Adams, instead of dropping the prosecution, reveals your office's insubordination is little more than a preference to avoid a duty that you regard as unpleasant and politically inconvenient. Your oath to uphold the Constitution does not permit you to substitute your policy judgment for that of the President or senior leadership of the Justice Department, and you are in no position to suggest that the President exercise his exclusive Article 2 authority to make your job easier. Beauvais then listed all the activities that Adams allegedly can't do because he's under indictment, such as communicated candidly with city officials and federal agencies. Now, I probably don't need to mention that there is no evidence that Mayor Adams can't coordinate with local and federal officials, and more importantly, none of these woes are the problems of the U.S. attorneys. If Adams can't perform his duties because he's on trial for bribes, then he can resign. And in any event, Texas Attorney General Ken Paxton was under indictment for 9 years and still managed to do all the things that he wanted to do, like prosecuting New York doctors for prescribing abortion pills and suing immigrants' rights groups for political speech. Now, once they accepted Sassoon's resignation, the DOJ reportedly asked John Keller, acting chief of the Public Integrity Section, or PIN, in Washington, D.C., to step in and carry out the order. He refused and also resigned. They then turned to the acting head of the criminal division, Ken Driscoll. He refused and resigned. And according to NBC News, at least 3 more senior attorneys in the PIN have resigned rather than carry out an order that they believed was corrupt, including at least 3 and maybe all 4 of the deputies in charge of PIN. Hagan Scotton, who clerked for Supreme Court Justices John Roberts and Brett Kavanaugh when he was on the DC Circuit, sent an absolutely scathing resignation letter. He said Beauvais wrote him a letter rebuking him for refusing to dismiss the case. Scotton says no one ever asked him to file the motion, but if they had, he absolutely would have refused. Scotton described himself as someone who is sympathetic to Trump's objectives. However, quote, any assistant U.S. attorney would know that our laws and traditions do not allow using the prosecutorial power to influence other citizens, much less elected officials, in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion. But it was never going to be me. That is perhaps the most fire-breathing resignation letter I have ever seen from an attorney. And he also pulled no punches in backing up Sassoon's substantive points as well. Quote, in short, the first justification for the motion, that Damian Williams' role in the case somehow tainted a valid indictment supported by ample evidence and pursued under 4 different U.S. attorneys, is so weak as to be transparently pretextual. The second justification is worse. No system of ordered liberty can allow the government to use the carrot of dismissing charges or the stick of threatening to bring them again to induce an elected official to support its policy objectives. And it's worth mentioning that Scotton was a captain in the Army Special Forces and served 2 tours in Iraq and earned 2 Bronze Stars. And following these high-profile resignations, Bondi and Beauvais went completely Squid Games. Former U.S. Attorney Barb McQuaid reported that, quote, DOJ leadership has put all Public Integrity Section lawyers into a room with 1 hour to decide who will dismiss Adams' indictment, or else all will be fired, setting them strength to stand by their oath, which is to support the Constitution, not the president's political agenda. This was the Attorney General of the United States threatening to fire an entire section of the Department of Justice, in particular the one charged with investigating public corruption, if they didn't sign a document that was going to risk their law licenses. But eventually Bondi and Beauvais found 2 people who will probably forever be labeled as a fool and a coward. Antoinette Bacon, a member of the Federalist Society, who they apparently pulled from Florida for this, and Ed Sullivan, a senior lawyer at Penn, who reportedly volunteered to save the jobs of the other lawyers at Penn who would otherwise have been fired. And why didn't Bondi or Beauvais file the motions on their own? Well, they absolutely could have done that, but they wanted to flex their power and they wanted a U.S. attorney to legitimize the decision to drop the case. When Sassoon said that the president should have instead used his pardon power, she was arguing that if he did, public perception would have been that the deal was simply a corrupt quid pro quo handed down by the top executive. So that's why they really wanted a U.S. attorney to file the motion. But now that Sassoon has effectively blown the whistle, filing this dismissal document is a hot potato for anyone's legal ethics. And as far as we know, at this time, at least 6 U.S. attorneys have resigned, and a large section of the Public Integrity Section has also resigned. That is at least 3 times as many who quit during the Saturday Night Massacre during the Nixon administration. And that purge actually triggered Nixon's impeachment. But in 2025, well... So what happens now? They have filed their request for dismissal, but Federal Rule of Criminal Procedure 48A says that, quote, the government may, with leave of court, dismiss an indictment, information, or complaint. So a federal judge can refuse a prosecutor's motion for leave of court to dismiss a criminal indictment, but only under limited circumstances. And I asked Mitch Epner what he thought would happen here.
I want to move forward to the next big actor in this, and that is Judge Dale Ho. If Emile Beauvais himself or find somebody at the Department of Justice to make the motion to dismiss, that motion will be presented to the trial judge, Dale Ho. I had the great fortune to work with Judge Ho when we were both near the beginning of our careers at a firm called Fried Frank. I've remained friendly with Judge Ho since then. until he took the bench. I know nothing about what Judge Ho thinks about this case. I do know that I've always greatly respected and admired him, his honesty, and his incorruptibility. Judge Ho is going to have a big choice. He could either rubber stamp the request from the DOJ, or he could ask the hard questions. Danielle Sassoon has predicted that Judge Ho will ask the hard questions, and I think that it is highly likely that she is correct. I'm quite confident that if Judge Ho asks the hard questions, the DOJ and Emile Beauvais will have no good answers. And the reason we know they have no good answers is the 2 letters that Emile Beauvais wrote are internally inconsistent, they are contradictory, and they make it clear that Danielle Sassoon is right on the law and they are wrong. Now, what can Judge Ho do if he thinks that this is a wrongful attempt to terminate? There are 2 things he could do. One is highly unlikely. The second is something that's pretty clearly within his powers. The highly unlikely thing he could do is insist that the DOJ move forward with the prosecution. As far as I know, that's happened once in the past decades. Danielle Sassoon cited that case in her letter. It's very rare. The thing that he could more easily do is he could deny the request to dismiss the case without prejudice, meaning deny the DOJ the opportunity to refile these charges at some later time and require them to make a choice. Do they want to move forward now, or do they want to dismiss these claims forever? That is something that is very clearly within his jurisdiction, and frankly, not particularly controversial. It would, however, put Judge Ho in the center of the MAGA media storm. I want to sort of wrap up by thinking for a moment of what does it do for Danielle Sassoon to stand up and say no, and if he does, for Judge Ho to ask the hard questions. It doesn't prevent the particular harm. It is likely that these charges will be dismissed one way or the other. It is an act of faith in the system. It is an act of faith that by shining a spotlight, acting as a speed bump, they will draw attention from US citizens who will say this is wrong and that it will not continue. Even if the charges against Judge Adams end up being dismissed, that there will be a price to pay because this sort of misconduct is not consistent with the ethics or the mission of the Department of Justice. So I think back to the first Star Wars movie, when Obi-Wan Kenobi realized that he no longer had the strength to beat Darth Vader in a duel, and he knew he was about to be killed. And he turns off his lightsaber and he meets his fate, saying to Darth Vader, "If you strike me down, I will become more powerful than you can possibly imagine." It is quite a sad day for justice in America. It's a sad day for the Department of Justice. And I am only thankful that I've been given this opportunity to share my thoughts. Thank you.
So it's hard to say what's going to happen next. I suspect Judge Ho will want to ask some very hard questions, maybe hold a contempt hearing, which he should. My hope is that he puts people under oath and at the very least creates a clear record. A clear record including putting one or more of the attorneys under oath, especially Emile Beauvais. You'll note that the Rule 48 motion for dismissal that Bacon, Sullivan, and Beauvais signed and filed with the court was very carefully written to put the onus on Beauvais. It places the action very carefully, like, quote, "The acting Deputy Attorney General has determined and directed. The acting Deputy Attorney General concluded that dismissal is necessary because the acting Deputy Attorney General also concluded that continuing these proceedings would interfere." So yeah, bring him and potentially AG Bondi into the court and make them make those representations under oath. Though I expect after this, they might just welcome a dismissal with prejudice just to get out of it. But this is a mess. It is a black eye for the Department of Justice and for the rule of law. It is one of the most corrupt, craven, lawless, and politically weaponized uses of the Department of Justice since Watergate. It's almost as bad as how data brokers use your private information for their own benefit, which you can fight with today's sponsor, Incogni. I'm really sorry. Our sponsors help make videos like this possible, especially on a 2-day turnaround, and Incogni is a longtime supporter and actually a good service. And it's especially important now that the data that the government has about you is now in serious risk of being compromised, if it hasn't been already. And all it takes is one hack for your personal and private information to be endlessly copied and sold to data brokers who then copy and sell it to anybody in the world for pennies on the dollar, leaving you drowning in scam calls, spam emails, and junk email. But luckily there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni. And you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If those brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. And now I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online and privacy is important to you, give Incogni a try. So if you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word. So after you click on that, click on this link over here for more LegalEagle, or I'll see you in court.